What is the one thing you can do during the course of your deposition that is virtually guaranteed to destroy your particular lawsuit? You want to know the answer? Come join me on this walk because I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is, the one thing you can do that will virtually guarantee that you will destroy your case during your deposition is to lie. Yes, to tell something that is not true, to testify about something that is not accurate. That is virtually the one thing that is guaranteed to totally destroy your case. Now, let me explain. I'm not talking about forgetting a particular fact. I'm not talking about not remembering something at the time or not remembering something accurately. I'm talking about actually lying, about creating a falsehood, about saying something that is totally untrue. So let me give you an example. If I were to ask you, hey, Mrs. Jones, when you're standing at the corner of Main Street and First Avenue, what was the color of the light? You have in your mind a distinct memory that the color of the light was green, okay? Whether it was or wasn't is a different story, but that's your memory. And now you're being questioned, you're being asked questions about this incident that happened 2 years after this incident occurred. And now you distinctly remember that the light was green and that the crosswalk said walk. Okay. Now, someone else who is standing at the street corner has a different version of what they remember. No, I remember that the light was yellow and that the light was flashing yellow, and I remember that the walk sign said don't walk. Okay, is that a falsehood? Is that a lie? No, it's not a lie. Why? Because this person is testifying about what they remember, about their recollection of the event. And they are consistent from the time that this incident happened up until the time that they are now being questioned in a pretrial question and answer session known as a deposition. That is entirely different. So now you have different versions of the events from people who actually witnessed the event take place. Let's say it was a car accident case, right? Now that is totally different than this type of question. Mr. Jones, have you ever been convicted of a crime? Have you ever been convicted of a crime? It calls for a simple yes or no answer. If the answer is no, what should you do? You say no, of course not. If the answer is yes, what should you do? You tell the truth. You say, yes, I have. And you're thinking, wait a second, if I tell them the truth, won't that destroy my case? Actually, no, just the opposite. It will show that you are truthful. It will allow your attorney to deal with the facts as they exist at the time, regardless of who you are, regardless of what has happened to you in the past. At least your attorney will be able to deal with it at the time of trial, if your case goes all the way to trial. If, however, you don't tell the truth, and now you are asked the question, hey, Mr. Jones, have you ever been convicted of a crime? And you have. Now instead, if you turn around and make a conscious decision to lie and say, no, I've never been convicted of a crime, that is going to be a problem. Why? I'll tell you why it's a problem. Because in these civil lawsuits involving accident cases, involving medical malpractice, involving wrongful death, your credibility is the entire case. If you are not credible, if you are not believable, there is no way a jury will give you money to compensate you for the injuries and the harms and the losses that you suffered. Why? Because they won't believe your story. They won't believe you. And you might be thinking, wait a second, this is just a small little white lie. What's the big deal? In all likelihood, the defense attorney won't even know about it. He won't even find out about it. There's no possible way he'll know whether or not I was convicted. Guess what? You are 100% wrong. I guarantee you that the defense attorney will do a background search on you. I guarantee you that the defense attorney will dig up whatever dirt they can find, whether it's on social media, whether it's on prior criminal record. They will dig up everything they possibly can. And then they will compare it to what you have answered in your pretrial deposition, your examination before trial. And if it turns out that you, in your wisdom, decided to lie, outright lie, guess what? You, my friend, have a big problem, because your entire case is based on credibility. Did you know that when your case goes to trial, at the end of the trial, in all likelihood, one or both attorneys are going to ask the judge for a legal instruction to give to the jury? It has a fancy Latin name called falsus in uno. It's a very, very powerful instruction. All right, what is it? It basically says, if a witness has testified falsely about one thing, You, the jury, have every right to disregard part of their testimony or all of their testimony. Could you imagine that? The jury has the right to disregard all of your testimony if they find that you have testified falsely about one single thing. They can disregard what you said about that particular answer, or they can say, you know what? If he's lied about this one little thing, this white little lie, this inconsequential little question and answer, how are we to believe him about all the other information he told us about? He's not reliable. I cannot trust him. Therefore, I'm going to disregard all of his testimony. That's how powerful that legal instruction is. So if it turns out you, as the person who is bringing this lawsuit, have actually lied about what occurred, and the defense finds out about it, which I guarantee you they will, your credibility is gone, which basically means, in all likelihood, you have destroyed your own case. So why do I share this with you? I share it with you just to give you an insight and an understanding into what actually happens in these civil trials in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.